In today's lecture, we consider the two most prominent forms of culpable homicide: murder, particularly second-degree murder, and manslaughter. The difference between murder and manslaughter is generally explained as a difference in fault. Whereas murder requires proof of a subjective state of mind, manslaughter involves an objective standard of fault. Indeed, the Supreme Court of Canada, in a case called Martineau, declared that Parliament is constitutionally barred from punishing or labeling conduct as murder where there is not at least subjective foresight of death. On this basis, the majority in Martineau struck down Section 230 of the Criminal Code. This section permitted the conviction of individuals for murder, what we might call constructive murder, merely on the basis that they ought to have foreseen that death was likely. What is the relationship between murder and manslaughter? Well, both are forms of culpable homicide, along with infanticide, which we're going to set aside for today. This is made clear under Section 222, sub 4 of the Criminal Code, which makes clear that culpable homicide is murder or manslaughter or infanticide. Must be one of those three. Section 222, sub 5 of the Code sets out how it is that one may commit culpable homicide. It states that a person commits culpable homicide when he causes the death of a human being by A, means of an unlawful act, B, by criminal negligence, C, by causing that human being by threats or fear of violence or by deception to do anything that causes his death, or D, by willfully frightening that human being in the case of a child or sick person. For the purposes of this lecture, I'm going to set aside subs C and D and focus on the two most common means of committing culpable homicide, by means of an unlawful act and by criminal negligence. In principle, it is impossible to have second-degree murder that lacks manslaughter as a lesser included offense. In other words, every instance of second-degree murder is in principle manslaughter plus subjective fault. So let's start by considering the offense of manslaughter, particularly unlawful act manslaughter under Section 222, sub 5, sub A. What are the elements for unlawful act manslaughter? Well, first, there must be an underlying offense, which may be an offense of subjective fault, objective fault, or strict liability. Second, the underlying offense must cause death, using the test for causation set out in Smithers and later in Nett. Finally, it must have been objectively foreseeable that the conduct in question would present a risk of bodily harm that was neither trivial nor transitory. So that's unlawful act manslaughter. What about criminal negligence manslaughter? What are the elements for that? And here we're looking to Section 222, sub 5, sub B of the Criminal Code. And here we're looking for an act or the failure to discharge a legal duty that causes death, again, per the test for causation set out in Smithers and Nett, that showed a marked and substantial departure from the norm. So these are the baseline forms of culpable homicide. What needs to happen to elevate these offenses to murder, second-degree murder? The core of second-degree murder is found in section 229 sub A of the code. It states, culpable homicide is murder where the person who causes the death of a human being either means to cause his death or means to cause him bodily harm that he knows is likely to cause his death and is reckless whether death ensues or not. With respect to 229 sub A sub I, note that there must be an intention to cause death. Oblique intention will also suffice, meaning that it is enough if the Crown can establish subjective foresight of a certainty of death. But an intention to cause mere bodily harm is not sufficient under 229 sub A sub I, nor is mere subjective appreciation of the mere likelihood of death. There must be an intention to cause death or subjective foresight of a certainty of death. What about section 229 sub A sub I? Well, in the case of that provision, we're looking for an intention or oblique intention to cause bodily harm, plus subjective foresight of the likelihood of death, plus recklessness as to the possibility of death. Let's now turn briefly to section 229 sub B. Now, I'm not going to read that provision. I'll just point out that it is, for the most part, identical in its requirements to section 229 sub A. But where 229B applies is in cases where the intended victim is not the actual victim. Let's suppose for a second that Alan poisons Ben's drink, intending to kill Ben, but instead Carl comes along, drinks the drink, and dies. Does the fact that Alan didn't intend to cause Carl's death, does that mean that he's not guilty of murder? Of course not. We transfer the intent to kill Ben to the intent to kill Carl. And we say, because by virtue of this transferred intent, this transferred fault, that Alan is guilty of second-degree murder. Likewise, if we imagine a case in which Alan fires a gun at Ben, intending to kill Ben, Ben moves, and the bullet hits Carl, killing him. Well, there too, we can transfer the intention to kill Ben to Carl, and thereby making Alan guilty of second-degree murder, pursuant to section 229 sub B of the code. Finally, let's briefly consider section 229 sub C of the code. Now, this is a somewhat complex provision with a complex recent history, at least. But suffice to say that this provision applies where the defendant did not mean to cause anyone bodily harm, did not mean to cause anybody death, but engaged in an activity in pursuit of an unlawful object that the defendant knew was likely to cause death, and in the course of engaging in that conduct did cause the death of another. that concludes my brief rundown through manslaughter and second-degree murder. See you next time.